Hello, everybody. This is Aaron Stempelitz from the Delaware Riverkeeper Network. I'm a staff attorney here, and I'm glad that you've all taken time to participate in our web series. So the Delaware Riverkeeper Network is convening a whole bunch of people, national leaders, local leaders in the battle against shale gas pipelines, and to share information and insight with communities battling pipelines throughout the country. We have a series of speakers, including attorneys, economic experts, advocacy leaders, all fighting shale gas infrastructure projects as participating in this series. This is the third of six of these presentations. The second of six of these presentations. The next one will be taking place on April 25th. And it deals with the economic impacts of pipelines, the arguments that FERC misses, and what we must raise. And it's going to be hosted by Spencer Phillips, who's an economist and principal, and also Sonia Wang, who's a policy analyst at Keylog Economics. So let's just give you a quick preview of what we have upcoming. We have several others starting on May 23rd, June 20th, and July 11th. But this web series is dedicated to the Clean Water Act and Section 401 water quality certifications. And what I'm going to do today is speak very briefly about, broadly what is the Clean Water Act Section 401 water quality certification, and then more specifically what the Clean Water Act Section 401 water quality certifications, how they interact with the Natural Gas Act and pipeline approvals. And I've prepared a few slides as well to go along and you'll be able to follow along. Just to let you know, we're recording this event and it'll be available later if you want to review some of the slides or want to review any of my comments, that it'll be available. Also, if you have questions as I'm going through my presentation, please just type them into the text box, and we're going to do our best to collect them and hopefully provide answers to as many of them as we can at the conclusion of my comments and my presentation. This webinar we started at 6:30. We're going to end promptly at 7:30. We understand that people have lots of things to do, and I'm going to try to be as concise and as informative as possible, but we're going to keep it to an hour. So let's get started. Again, my name is Aaron Stempelitz. I'm an attorney at the Delaware Riverkeeper Network. Just to give you a quick background on myself, I started with the Delaware Riverkeeper in August of 2011. And sort of became the resident expert here at DRN regarding pipelines. I had a little bit of background in natural gas hydraulic fracturing. Didn't really have a whole lot of experience with pipelines, but it's been the focus of most of my work over the last 5 years or so. So I've gotten some bumps and bruises along the way, but hopefully I'll be able to provide some insight on the intersection of the Clean Water Act and the Natural Gas Act here. So first, I'm going to answer some basic questions. What is the Clean Water Act? What's a 401 water quality certification? What is required to get it? What does that mean in the context of what power do states have over natural gas pipelines? FERC jurisdictional, Federal Energy Regulatory Commission jurisdictional projects. What is the current legal sort of landscape? I'm going to provide you with some really up-to-date information on existing cases and existing case law, and up until this, we'll have updates from cases that are ongoing or have been initiated as of this month. And we're going to talk in that same context some of the good ways and some of the bad ways that states are using or more frequently are not using this authority. And hopefully as part of my comments today, I can help provide you some context if you as a citizen want to become involved in commenting on Section 401 water quality certifications and being engaged in this federal authorization that is necessary for all pipeline projects. So let's start with an oversight of an overview of what this certification is. Ultimately, the Clean Water Act delegates the power to implement Section 401 water quality certifications to the states. So each one of the states individually implements slightly differently the Clean Water Act certification and how you get one and what are the standards, the timing requirements. Much of that is dictated by the states. And the ultimate purpose is for FERC or any project that triggers a Clean Water Act certification is to comply with federal and, more importantly, state water quality standards. So to give you some context, in the state of Pennsylvania, a lot of the water quality standards are contained in Chapter 93, Chapter 105, and Chapter 102. And so as part of a Clean Water Act certification for the state of Pennsylvania, a project applicant will have to show compliance with those specific water quality standards as codified in the Pennsylvania Code. And it's sort of similar with New Jersey, with New York, with any state, even going, out west. It's all pretty much the same general concept. So let's start with really the statutory language of the Clean Water Act, and specifically Section 401A1. So Section 401A1 of the Clean Water Act gives states the authority to veto or place conditions on federally permitted activities that may result in water pollution. And I've pulled out language from Section 401A1, which is quite long, but I pulled out a few key provisions that I just want to focus on in these comments. The first quote just indicates that any applicant for a federal license or a permit to conduct activities is required to get a permit where there may be a discharge. And the second portion here is no license or permit shall be granted until the certification required by this section has been obtained or has been waived. The third provision here is no license or permit shall be granted if certification has been denied by the state or interstate agency. And last, if the state fails or refuses to act on a request for certification within a reasonable period of time, which is not to exceed 1 year, the certification requirements may be found to be waived. So pursuant to these sort of four smaller sections of 401A1, we're gonna break them down, what they mean, and specifically what they mean in the context of FERC jurisdictional pipeline projects. So the first question is whether or not Section 401A1 even applies to the FERC certification of public convenience and necessity. I mean, that's the threshold question. And so if you go back to the language and you read that first little bullet point of mine, you see any applicant for a federal license or permit. So the question is a FERC certificate a license or a permit? And in recent litigation that we've had against the Federal Energy Regulatory Commission in the D.C. Circuit, the industry attorneys were arguing that a license or a permit a certificate is not a license or permit. So therefore, the FERC certificate was not the federal authorization that initiated the requirement to get a Section 401 water quality certificate. And the counter argument to that we presented in court and that we presented in our briefs was that courts interpret statutes according to their plain meaning. And the plain meaning of license or permit, as if you look them up in Black's Law Dictionary, necessarily includes certificates, such as those issued by FERC. The definitions for license or permit are really, really broad. And in oral argument in that case that you see the citation there for, the judges didn't even bring up this issue. I don't think that they saw it as being a problem or being, frankly, a credible argument. So I think we're beyond that, but it's an argument that keeps popping up in some of the briefing for on the industry side. So after we've established that that a FERC certificate initiates the requirement to have a Section 401 water quality certificate from the state, what can the states do? Well, they can do one of four different things. One, they can certify the project. Two, they can certify the project with specific conditions. Three, they can deny the certification. Or four, they can either waive their certification authority or just not act within the period of a year, and that basically acts as a waiver of their certification authority. So with regard to denying certification, one of the things that states can do, Section 401A1 specifically empowers states to condition and, where appropriate, block FERC jurisdictional energy projects. That is well established in law, and there's a citation there for that. If a state imposes conditions in its water quality certificate, those conditions are incorporated into federal license. Here, it would be a FERC certificate for a natural gas pipeline project. Now, a state can block a Section 401 water quality certification where the project will result in a violation of state or federal water quality standards, more likely state water quality standards. And as I was saying earlier, each state's water quality standards are different. So if you're interested in a pipeline project in your area or in your state, and you want to and you're thinking about the Section 401A1 water quality certificate, the first thing you should really do is become intimately familiar with your state's water quality standards, where they are, what they are, and what they mean. And then after that, you can look at the proposed project that you're interested in and see whether or not there are portions of that project that may violate one of your state's water quality standards. And that's really a typical way. It's a good process for if you want to comment and if you want to become engaged in a certain project. And I'm going to run through a few quick examples of where states have actually denied Section 401A1 water quality, where they've denied these sort of certificates. And the first one, and probably the most well-known one, is the Constitution Pipeline, the case of the Constitution Pipeline Company. And the Constitution Pipeline project was a 125-mile greenfield natural gas interstate transmission project that stretched between New York and Pennsylvania. And Constitution was granted a certificate from FERC on December 2nd, 2014. The docket number is there on the screen here. In April of 2016, the New York State DEC denied the Section 401 certification, saying the application fails to in a meaningful way to address significant water resource impacts that could occur from this project. And so that was the first time that I had seen, and again, I started in August of 2011, but the first time I had seen a state deny a Section 401 water quality certificate for a FERC jurisdictional pipeline. Now, Constitution filed a complaint in the U.S. District Court for the Northern District of New York in May of 2016. And they essentially argued that New York State was preempted from issuing the Section 401 water quality certificate and the sort of related underlying substantive permits that make up the water quality certificate. We, the Delaware Riverkeeper Network, filed a motion to intervene on behalf of the state because we wanted to preserve the state's right to be able to enforce their water quality standards. We also simultaneously filed a motion to dismiss. The state also filed a motion to dismiss. And on March 17, 2017, the court dismissed the case by issuing an order. And a lot of it actually followed a lot of the rationale provided in our motion to dismiss. essentially finding that the injury to Constitution arising from from New York DEC's inaction would be based on speculative chain of possibilities that may never occur. In addition to preemption, the Constitution was also arguing that essentially DEC was holding some permits back that they could later deny if they wanted to. And essentially the court said, well, there's this other set of pending litigation, and that if you're not successful in this other pending set of litigation, this case is essentially irrelevant because there's no project. The project won't be able to proceed. And that other piece of litigation was a case that Constitution filed in the Second Circuit, basically challenging New York State's denial of the 401 water quality certificate. Just basically saying that, making two essential arguments. One, that DEC waived their right to issue the permit because it took longer than a year to do it, and two, that the decision was arbitrary and capricious because essentially they're arguing it was politically motivated rather than substantively motivated. Oral arguments took place back in November 2016 for that case, but no decision has been rendered from that court. If that court denies Constitution's requests, that's pretty much the end of that project. I mean, despite the fact that Constitution has their FERC certificate, they can't do anything without the 401 water quality certificate. A second example is the Northern Access Pipeline. This is a pipeline, a 99 mile pipeline that's 24 inches in diameter to interstate natural gas pipeline, again in New York. For this project, FERC issued a certificate in February of this year. And on April 7th, so just 11 days ago, New York DEC again denied the Section 401 water quality certificate. And using similar language, they say the application failed to demonstrate compliance with New York State water quality standards. New York State DEC actually argued that the project warranted a full environmental impact statement review by FERC rather than an environmental assessment. So they weren't happy with the way FERC was dealing with this project either, let alone the way in which the application had come to them, which I found rather interesting. Now, Northern Access has asked FERC to waive the requirement for the Section 401 water quality certificate in a rehearing request, but that has been currently tolled by the Commission. So essentially, the order issued by FERC is essentially an indefinite extension of time for FERC to consider Northern Access's request for rehearing. And considering that we don't have a quorum at FERC, it could take quite a long time for a final decision to be made there. So we'll be following that case rather closely. I've never seen, in my experience, any non-industry party be granted a rehearing request by FERC. Now, this is Northern Access; they are necessarily industry, so it'll be interesting to see if FERC sort of changes their tune and decides to grant that sort of request. So unfortunately, these are really the only two examples that I'm currently aware of where a state denied a FERC jurisdictional pipeline project a Section 401 water quality certificate. And so, while states have great power to get the maximum amount of protection, for environmental protection for these projects, most states fail to either, one, comprehend their authority and understand the power that they have, two, or perhaps they're unwilling to face potential lawsuits from the pipeline companies, as New York State DEC is. But clearly New York State DEC is not intimidated by these lawsuits, and to the extent that they're buttoned up and they have well-documented reasons for denying the 401 water quality certificate, then they should have no problem doing so. And that's where that's where it's really helpful to have informed comments from the public coming into these different state agencies identifying problem areas, identifying endangered species, or a modicum of whatever issues you feel are important and have some sort of impact on your state's water quality. It's really important to be engaged and make those comments and really focus the state's attention on these different problem areas. Because without engagement of the public, you're really relying on your state. And if you live in Pennsylvania, it's very unlikely that the state is going to deny a water quality certificate. I've never seen it. Even in cases where we see really significant impacts to water quality standards and have experts showing that and commenting that they haven't been willing to go there. So the other advantage is if you can't convince your state agency to deny a permit, by commenting, you also build the record for a later legal challenge. And it might not even be you initiating the legal challenge. Your comments can be used and relied upon by whoever's bringing the lawsuit, because they're part of the administrative record. And all of these cases are record review cases. So again, it's really important to stay engaged, because maybe if you don't bring a lawsuit because you don't have the time or the resources, maybe your neighbor does, and they'll be able to rely on those comments that you make. So it's a benefit to the collective, the collective group of people involved in any one project. It's to everyone's benefit that you comment and take the time to do so. So I'm going to talk really briefly about the timing of the Section 401 water quality certificate and why the timing is so important. As we went over earlier, there's a provision in 401A1 that says, no license or permit shall be granted until the certification required by this section has been obtained or has been waived as provided in the preceding sentence. So that provision indicates that states really have great power to block a project, because many states will not issue a 401 water quality certificate based on remote sense data. So in other words, like if you have a project where a significant percentage of landowners refuse access to a pipeline company, the state isn't going to issue its Section 401 water quality certificate just based on remote sense data via their alignment sheets from aerial photographs. Most of the states really want to see on-the-ground field inspections. And if you're a landowner and you have a bunch of wetlands on your property and you don't like this, pipeline project for whatever reason, and you believe it's going to harm the resources on your property, you can deny access for a period of time. Now, when FERC issues its certificate, basically that gives the power to the pipeline company to go to court and through eminent domain get access to your property. So what we see very frequently is the 401 certificates being issued well after the FERC certificate. And we see that because, as I've been explaining, the FERC certificate is the legal instrument that gives the power of the pipeline company to go to court to gain access to your property so they can survey it, so they can then get the 401 water quality certificate. Now, all of that is, interestingly enough, seems to be prohibited, pretty expressly prohibited by the clear language of Section 401A1, which says no license or permit shall be granted until certification required by this section has been obtained or has been waived. And so we brought a challenge to this really continuing practice of FERC issuing its certificate prior to the state issuing its 401 water quality certificate. And we did that in Delaware Riverkeeper Network v. FERC, which was in the D.C. Circuit, the docket number 16-1092. And oral arguments literally just took place on April 4th of 2017. The court really had concerns that the FERC certificate was only conditional and not final, and therefore there isn't necessarily a problem with complying with 401A1 because basically the court was saying, well, really, what is your harm? This is just a conditional certificate. It's not really allowing anything to happen that would violate water quality standards. We pointed out that tree felling activities often do take place. And we brought up the example of the Constitution pipeline, where this exact situation occurred, where you have FERC issue their water quality, FERC issue their certificate. They got access to people's property. And they began construction without New York's 401 water quality certificate. And later we know that that New York State denied it. So with Constitution, because they had the 401 in Pennsylvania and they had the FERC certificate in Pennsylvania, they cut down all these trees and allegedly some trees in New York, but not necessarily all of the trees in New York. But a large swath of right-of-way was cut for a project that would never proceed. And I made that argument to the court, saying, look, there's no way to prevent this from happening again if we allow FERC to continually issue their certificates prior to the 401, because we're going to be stuck with situations where certain construction activity proceeds for a project that eventually gets blocked by a state. And FERC nor the intervener, the gas pipeline company, really had an answer for that. I don't know how it played with the judges, but we'll find out in the next couple of months. And the other counter argument to that is that if you issue the Section 401 water quality certificate, looking at the substantive impacts to water quality in a state, if you're issuing that permit after the FERC certificate, that means that there may be information that comes to light in the 401 water quality certification that materially conflicts with the environmental assessment or the environmental impact statement that occurred prior to FERC issuing their certificate. So you have this conflicting information, and you have basically FERC making a decision on whether or not impacts are significant based on incomplete information. So we also made that argument to the court. The panel was comprised of Merrick Garland, Judge Griffith, and Judge Edwards. And Judge Edwards had previously been a judge on a separate case, on our segmentation case back in 2014, and was one of the judges who voted for us. And he asked some very skeptical questions. And interestingly enough, Judge Griffith, who is a more conservative judge, was more sympathetic to our argument. So you never know how these things are going to go, and we're eagerly waiting in the next 2 months. So keep an eye out for how that goes. So as I was saying before, Section 717 RD1 of the Natural Gas Act dictates that any challenge to an authorization, such as a Section 401 water quality certificate, is heard by the appropriate Circuit Court of Appeals. And these cases are record review cases, which means it's not a trial. You don't put on experts. You don't do cross-examination. There's no discovery. Instead, it's a record review case. So the only thing the court looks at is what information was before the agency at the time the agency made the decision, and subsequently whether the decision that the agency made based on the information in front of it was arbitrary and capricious or not in accordance with law. That is the standard. So again, that's why I was saying earlier, it's really important to build a really good record through comments and being engaged with your state agency issuing the 401 water quality certificate. The other really important part of Section 717R of the Natural Gas Act is that it requires expedited consideration of all petitions for review. And what that means is that without expedited review, securing expedited review, a lot of times if you challenge a 401 water quality certification, you go through the litigation, sometimes by the time the court issues a decision, the pipeline's already in the ground and the harm's already done, and it's hard to get meaningful judicial relief. One option is that you can request expedited consideration of a petition for review. And that means you could get the briefing done in potentially as quickly as 35 days, and maybe get oral argument very quickly after that, and potentially a decision within a month or two after that. So you're talking about, maybe 4 months. I mean, if you're really moving. So that's something to keep in mind, that not a lot of groups have been taking advantage of, who have been challenging FERC jurisdictional projects, and specifically 401 water quality certificates, or even FERC certificates. I mean, it could be any challenge to any state or federal permit that is issued pursuant to the Natural Gas Act. All of them are required to undergo expedited consideration. Additionally, so another provision in Section 401 states that your state or interstate agencies shall establish procedures for public notice of applications for certifications by it. So if you're interested in a particular project, there should be some sort of public notice provided to you. If there's no public notice provided for your Section 401A1 water quality certificate, that's a reason to get into court, because as I've discussed earlier, this is a record review case, and you can't submit comments to eventually challenge a certification if you weren't made aware of it, and that language is right in 401A1. So be on the lookout for that for your different projects. That's a really important issue. Everybody should have the opportunity to comment on these types of things. So I'm going to talk also a little bit about another DRN challenge to a Section 401 water quality certificate, and this has to do with a Third Circuit case involving the Leidy Southeast Expansion Project, and the docket number's up there, 15-2122. Here, in this case, the state of Pennsylvania Department of Environmental Protection issued a Section 401 water quality certification that was conditional. We hadn't seen that before. And for prior projects in the state of Pennsylvania, basically what Pennsylvania did was they stamped their substantive Chapter 105 permits with a little sentence that reads, this Chapter 105 permit also constitutes your federal Clean Water Act Section 401 water quality certification. And all of a sudden, I guess a couple of years ago, all of a sudden the department sort of changed their procedures, and instead what they did is they issued a permit that essentially acted as a promise that the applicant would later get all of the substantive state permits. So in other words, the permit read, the certification, the Section 401 certification read something along the lines of, we certify that this project complies with the Clean Water Act, such that the applicant eventually received their Chapter 105 permit, their Chapter 102 permit, their NIPTES permit, and a few others. So essentially what PADEP was doing was issuing a Section 401 water quality certification without reviewing any of Pennsylvania's state water quality standards, because those state water quality standards are codified in these different state permits, the Chapter 102, in particular the Chapter 102 and Chapter 105 permits. So we argued that the Pennsylvania Code and PADEP's own guidance documents require it to issue the Section 401 water quality certification at the same time as the substantive 105 and 102 permits. And the past practice of PAYDEP was exactly that. That's exactly what they would do. They had changed it in this case. And the court ended up disagreeing with our argument, and not necessarily with the merits of our argument, that the code and PAYDEP's own guidance documents require that the substantive review happen at the same time that the 401 water quality certificate is issued. But what they said was that we were never, Delaware Riverkeeper was not harmed by the delay in the issuance of those, in the review of the substantive portions of the water quality standards, which happened months later. We made some arguments to the contrary, and we submitted a panel rehearing request, and the court did modify a couple portions of their opinion because they agreed with that they had made some mistakes in their rationale, but they didn't change the holding of their case. The good news coming out of that case is that the heart of the arguments here are still undecided. So the merits of our arguments that the code and PAYDEP's guidance documents required to issue these permits simultaneously, that argument wasn't responded to in the court's opinion. So to the extent that a party, or to the extent that Delaware Riverkeeper brings another case and can show harm, you can get right to those arguments, and we can decide once and for all whether or not PAYDEP can issue water quality certificates without reviewing any actual water quality standards. Now, an important part of that case found that any appeal of a Section 401 water quality certificate issued by the state goes directly to the circuit court without going through what may be the normal review process before for example, in Pennsylvania, the Environmental Hearing Board. So, so typically when, for example, the Pennsylvania Department of Environmental Protection issues a Section 401 water quality certificate or the underlying Chapter 105 or 102 permits, if those are issued pursuant to a non-FERC jurisdictional natural gas project, so the Natural Gas Act is not in play here, what happens is an appeal goes right to the Environmental Hearing Board. And at that point, it's a de novo review, which is different from a record review. It's a de novo review at the Environmental Hearing Board, which means it's like a mini trial. And you put on experts, and you do cross-examinations, and it's essentially a mini trial. And then the Environmental Hearing Board rules on whether or not the department was justified in issuing the certificate, the 401 certificate, or the underlying state permits. The holding in our Third Circuit case was that the appeal of the 401 water quality certificate and the underlying state permits goes right to circuit court and does not involve the Environmental Hearing Board. Interestingly, very recently in a case called Berkshire Environmental Action Team versus the Tennessee Gas Pipeline, which is a case in the First Circuit, petitioners brought a case to the First Circuit and made an interesting argument. They essentially said, court, please either stay or dismiss our action that we brought before you and allow us to go through the normal review process, appeals process at the state level first. And the court essentially agreed and agreed that there was necessarily no final agency action because the appeals process sort of hadn't been exhausted at the state level, so that these permits and certifications were not final. So what that means is that we may have a circuit split between the Third Circuit and the First Circuit on the issue of how these Section 401 water quality certificates are judicially reviewed. And if you're a follower of the Supreme Court, you know that the Supreme Court is much more likely to take on a case where there is a circuit split between how the circuits decide a case. So I honestly would not be surprised to see either a gas pipeline company in the First Circuit or a third party, an environmental group in the in the Third Circuit end up bringing a case that eventually works its way up to the Supreme Court. Again, that takes a lot of time, but I mean, the way that I read those two cases, I definitely see a little bit of a circuit split. A lot of the logic that the First Circuit used really does apply to the Third Circuit. So that's a really interesting development, and it's something to follow closely if you're interested in Section 401. The last thing I'm going to talk about is another lawsuit that we've brought against the Pennsylvania Department of Environmental Protection. Again, it's in the Third Circuit. The case number is up there, 17-1533. And in this case, again, PADEP issued a conditional certification. And instead of challenging the problem with the timing of the underlying permits and the Section 401, we just challenged the underlying substantive Chapter 105 water obstruction and encroachment permits. Essentially, we contend that Pennsylvania unlawfully issued a permit to a project that necessarily violates a water quality standard. And the specific water quality standard we talk about is Section 105.18 AA2 of the Pennsylvania Code, which states that no non-water dependent project may encroach on exceptional value wetlands. So pipelines are not water dependent projects. We all know that you can build a pipeline and operate a pipeline in a desert. The Pennsylvania Department of Environmental Protection for a number of years has been categorizing pipelines as water dependent projects. And we believe that this is a mistake, and that if you look at similar language in the Clean Water Act with regard to water dependency, you're going to find that there is no court in any jurisdiction anywhere that has ever found a pipeline specifically or linear infrastructure generally. You could be talking about any type of linear infrastructure, whether it's roads, highways, whatever, as being water dependent. We've requested expedited hearing of this case, and we're eager to hopefully, with any luck, get a decision out of the Third Circuit sometime this summer. This project has to do with the Tennessee Gas Pipeline Company Orion project, so we'll see where it goes. So those are, the legal landscape of what's going on and the different challenges that have been recently brought, and what I think are some interesting issues. So right now I'm going to take a quick look at some of these questions and try to get through as many as I can. I see there's a bunch on here. If you just give me one moment, I'm going to take a quick look and I'll So the first question is, if we get into litigation in our states, will DRN let us use its briefs? And they're all public records, so we'd be happy to share briefing with you. They're all on Pacer, and so we're more than happy to share whatever briefing we have in the courts. I know it's a little bit of an expense to get it through Pacer sometimes, but we're happy to share with you. So please email us, and like I said, we're more than willing to help folks out. Another question is, does receipt of a 401 application by the state agency start the one-year clock for approving or denying or waiving certification? That's a really good question, and one that's being currently litigated. So essentially, one of the arguments in the Constitution pipeline matter that's currently pending before the Second Circuit is the Constitution is arguing that as soon as they submitted their application to New York DEC, right at that very moment, that starts the clock. And DEC has to make a decision on that permit within a year. And New York DEC is saying, well, not so fast. The one-year clock really starts when there's a complete application. For example, Constitution could have waited until the 364th day to complete to complete its application, and then we'd be required to go through an entire application in one single day to make a decision. I think the counter argument to that is that, well, then just deny the permit. Deny the permit and make them resubmit. So I think really that can go either way. I mean, there's clear intent in Section 401A1 that some action be taken in a year, and it's not real clear when that starts and when that stops, and the case law also is not particularly clear. So it comes to a matter, I think, of there's a public policy argument in there. There's general fairness issues at play, and so it'll be really interesting to see how the Second Circuit comes out on that issue, or whether they try to kick it down the road and sort of not decide the case on that issue. Another question is, does this only apply to navigable waters and not apply to smaller streams, no matter what their quality classification may be, EV, EQ, etc.? So your Section 401 water quality certificate has a little bit different of a standard for what results in a discharge as compared to Section 404. So with regard to navigable waters, as you know, the term navigable waters is fraught with uncertainty on exactly what that means. But if you have any length of a pipeline project, whether it's, even if it's as small as a couple miles, chances are you're going to be crossing some sort of jurisdictional waters that are hydrologically connected to navigable waters or are navigable waters themselves, and therefore trigger the requirements of Section 401A1. And this brings up another important point. The difference between Section 401 of the Clean Water Act and Section 404 of the Clean Water Act is really important to understand. So Section 404 of the Clean Water Act involves a permit being issued by the Army Corps of Engineers. And the triggering mechanism in Section 404 is any discharge of fill or dredged material into navigable waters. Whereas 401 is any discharge. So it doesn't have to be dredge and fill. So 401 is necessarily significantly broader in the scope of activities that trigger it than Section 404 of the Clean Water Act. And actually, that is an issue that the Third Circuit really bungled in their decision, is not really understanding the difference between what the Army Corps does and what the states do. And so I think, again, something that we can do as constituents and citizens and active citizens is educate our states on the far broader scope of their powers as compared to what the triggering mechanism in 404 of the Clean Water Act, which is usually under the Army Corps' jurisdiction. Taking a look at a few others. So another question is slightly unrelated to Section 401, is do landfills fall under 404? It depends. It depends on whether or not there is a wetland there that ends up getting filled in some capacity, or whether there's any dredge and fill activity on that property related to a jurisdiction, a Clean Water Act jurisdictional resource. And again, I think it's really important to understand the distinction between 401 and 404, and really understand that Section 401 is a really powerful tool for the states to use, specifically in the context of pipelines. And we've seen New York State really flexing its muscles on this, and I think that's great that they're now understanding what kind of power they have. We'll see if other states are willing to follow their lead and sort of assert their authority, because right now, as many of you may know, FERC is the Federal Energy Regulatory Commission, for all intents and purposes, is really nothing more than a rubber stamp agency. You're not going to see FERC denying a natural gas pipeline project unless, of course, somehow that pipeline project doesn't have any contracts associated with it. That's, but as we all know, that generally doesn't happen. So FERC essentially has a 100% approval rate for a natural gas pipeline project. So it's I think, helpful to look for other ways to get engaged on pipeline issues, and this is certainly one of them, and certainly one that I think we're beginning to see some increased activity and increased interest from states. So with that, I'm gonna conclude this webinar. Again, my name is Aaron Stempelwitz at the Delaware Riverkeeper Network. If you have specific questions, feel free to reach out to us, and we're busy here, but I'll do my best to see if I can respond to any of your questions. And again, if you're interested in seeing this presentation, particularly if you're listening on the phone and you're interested in some of the citations to the legal cases, they're on the PowerPoint presentation, and you can see them in this recording that we're providing. Thank you all for taking the time. It really is much appreciated. I'm so happy to see so many people are engaged, and I look forward to seeing you again at one of the next webinars that we have coming up. Again, I'll just quickly say April 25th, May 23rd, June 20th, and July 11th are the next 4 dates. So thanks a lot for coming.